Great, welcome back. Our final segment for the day is new to the agenda this year. Our executive seminar series is designed to again promote greater industry insight from the top-level professionals. Our executive seminar series begins with Zach Hammerman. Zach is an associate in the Intellectual Property and Technology Transactions practice groups. He will spend the next 30 minutes discussing the legal implications of SaaS and his practice providing strategic counsel to clients' development, acquisition, and commercialization of intellectual property and technology. Mr. Hammerman received his JD in 2002 from Stanford Law School, where he was awarded the ABA and BNA Books Awards for Excellence in Intellectual Property. He received his AB in Comparative Literature from Stanford University, where he graduated Pi Beta Kappa with departmental honors and distinction. Welcome to our group, Zach.
Thanks. Good afternoon. I joined and listened to a bit of the user group and panel discussion immediately before the break, and I was very interested by the final question asking if you had unlimited funds, what would you do to increase the performance of your hospital? And I didn't hear any of the panelists say that they would hire more attorneys. I can't imagine why that was. My goal this afternoon is really to change your mind about that, specifically with respect to technology procurement in the hospital and healthcare environment. As was discussed in my introduction, I'm a slightly different type of attorney. I'm a technology transactions attorney. That means that I really have a background in both intellectual property and the commercial aspects of technology transactions. I'm at a firm, Greenspelter, Hemker & Gale in St. Louis, Missouri. We're a firm of 160 attorneys, a full-service firm with a significant healthcare practice. We represent hospitals, physician practices, imaging and surgery centers. My role in that work is to represent them in their technology, information security, and privacy needs. In that capacity, I've assisted with deploying wireless networks, with procuring imaging modalities, custom development of bar scanning software for push carts, developing a custom in-room drug cabinet and some software that went along with that, and then obviously all the day-to-day and significant investments in technology that go into hospital, the EMRs, PACS, RIS, and other systems that are the core backbone of the hospital and our physician practice operations. What I'd like to discuss with you today, despite the introduction and the teaser that we were going to talk about SaaS, I actually want to talk to you about something that I think is fundamental and I think is being lost in a lot of the presentations I'm seeing on cloud computing and outsourcing and hosted solutions. And that is the fundamentals of structuring the vendor relationship itself. Because at the end of the day, whether you're licensing in software to deploy in your environment or you're working with a vendor who's actually going to host and operate that software for your benefit, we're talking about structuring a relationship. And in my role as legal counsel, both for technology companies like Formfast, as well as for our healthcare clients, I see some recurring things that concern me and that we try to assist in when trying to structure these deals and ensure success. And I think at the end of the day, that's where the vendor and the hospital are aligned, and that they both want a successful partnership. What I'd like to share with you today is really some tips about what you should be thinking about at the front end that can increase those odds going forward from a legal, structural, and contractual point of view. So starting with an overview of the technology procurement process, I think this should be familiar to most of you on the call in that we really begin with the strategic planning and budgeting process internally that leads to the decision that new technology is going to be purchased or existing technology needs to be upgraded or modified. And if it's new technology, then often the next step is that vendor selection process. Sometimes that's with the assistance of internal IT personnel. Sometimes that's where, if you're fortunate, an outside consultant may come in and help assess your requirements and assist in pointing you in the right direction of some of the leading vendors. Once that vendor selection process concludes, there's the contract negotiation, and depending on the deal, that might be pro forma, that might get legal review, it might not. Different organizations have different cutoffs there in terms of strategic importance and spend. But the whole point of that contract is really to set expectations between the parties for the implementation and launch of the project, ongoing maintenance and support of the technology, and some of the outer contours of the relationship. What happens when this relationship ends? Who has the right to decide when it ends, and how will it affect my organization? So when thinking about that, what we see is that often there's focus on one or two of those aspects of the relationship, but not all of them. And we think that's often because the right team may not be in place from the beginning to help out with the project. And so the first thing when I sit down with a client, we think about a new technology procurement transaction, especially one like the procurement of an EMR or anything with mission-critical significance. We try and identify the stakeholders for the project who need to have input from the beginning. And that's obviously the business, financial, and information technology leaders of the organization. It's also legal and compliance and risk management, sometimes an outside consultant. And often we see that these different personnel are brought together and they're at the table at least for a kickoff meeting, at least for an overview, or perhaps they'll have something delegated to them. The problem that we see, though, is that there's really not a coordinated effort among the internal team driving towards the same end result. And we see this as a couple of problems. And the first is a problem of delegating down, where senior leadership may have a vision of what it's hoping to get out of the relationship and what's important to it in the relationship. But the task of actually structuring that relationship is delegated down to someone that doesn't have that insight and doesn't have that decision-making authority. Similarly, we see a problem where the tasks are divided up, and a project that requires coordinated effort is actually divided into smaller manageable subtasks and given to a variety of individuals at the organization to handle each discrete piece, but no one really has a handle or transparency into the overall transaction and how all the pieces fit together. And as we go through this presentation, I'm going to give you some examples of how that occurs and what can be done about it. But I think for this initial team building phase, I think the important thing to keep in mind is that it's not just who you bring to the table, it's the role that you give them. And with my clients, we really focus on a process-based technology procurement where we have a set of tasks, we have a task list that's shared among all parties, we have deadlines that are set for each individual and transparent to all parties, and most importantly, we have an issues list that's a master list that everyone is expected to contribute to as problems arise or as questions arise, and the project doesn't close until all the issues on that master issues list are resolved. And we found that it's really that process of making sure that everyone's in the loop and that there aren't information gaps internally in the process that help us arrive at both choosing the right vendor and negotiating the right contract. A final note on that, I guess, would be messaging by senior leadership. And I know we have many senior leaders on this call. I want to mention that one of the largest problems we see at large organizations especially, including our hospital clients, is that the team on the ground, the message that they bring to the table is, we need to get this solution implemented yesterday at the lowest possible price without any problems whatsoever. And when that message is what's signaled from senior management to middle management down to the individuals who are responsible for deployment, what you end up with, we found, is a tendency for people to want to not raise the issues as they arise, not be the one who might hold up the process, not be the one who raises those red flags. And we work really hard with our senior leaders to send the opposite message, which is, we want the right relationship at an appropriate price, but we want a relationship that makes sense for us and is consistent with our mission. And we found when that's the message that's sent, you get better decision-making, better responsibility, and better follow-through all the way down the line. The first aspect of the vendor selection process I wanted to touch on this afternoon is the requirements definition phase. I think that we're all familiar with the RFP and the importance that the RFP can play in eliciting information about the vendor and its technology. The problem we found is that too often I see a hospital look to the vendor to educate it about the vendor's technology and what functionality is feasible and what options are on the horizon, and really treating it as an RFI, a request for information, rather than an RFP. That is, it's an information gathering document rather than a requirements definition. This would probably be fine if an EMR or other hospital technology were a phone and you could simply plug it into the jack and start talking. In reality, though, the EMR and other hospital technology has numerous interdependency. It isn't off the shelf or plug and play, even when a vendor assures you that it is. There's always some level of configuration or customization or interface development that needs to occur in order to make the solution right for your environment. So, as a first step, before bringing any vendor to the table for serious discussion, I really recommend putting together a requirements definition that accounts for the particular and unique creature that your organization is. And again, this can be done as a collaboration between business and IT leaders, or can be done with the assistance of an outside consultant who specializes in these issues. Although, if you do engage an outside consultant, I think it's important to make sure that your internal team doesn't think that means they can abdicate the function, because a consultant can offer you kind of their cookie-cutter recommendation for what hospitals generally should expect from a particular technology solution. But your goal here really is to assume that most of the vendors meet that standard definition. Your objective is to figure out the delta between what most hospitals would expect and what your organization needs, and to focus your vendor selection and due diligence on your unique requirements. The RFP response itself can be tricky. The recommendation we provide clients is to really add a third column. Yes, no isn't sufficient. The reality is that when vendors are responding to your RFP, it's usually in their sales phase, not their relationship or contract phase. And so the sales force is very happy to check yes whenever possible, even if they have to stretch things. When you provide a third option, which we usually call the mod, you see a different set of responses. And the mod is, yes, your technology can perform or meet this requirement off the shelf, or yes, your technology is capable of meeting this requirement, but only with customization or configuration. And that's an important distinction because we've often found that a vendor is selected based on RFP response where the vendor looks like the Cadillac solution and it can do everything. And then when it comes time to work on the statement of work for implementation, they realize, well, in theory it can do everything, but it's going to cost 5 times my upfront investment to customize and configure the solution to make it work that way. So hand in hand with eliciting information from the vendor, an area that we found shortcomings in these days especially has been the art of the reference check. Many of our clients view reference checks as pro forma, and indeed if you go through the motions on the reference checks, that's exactly what they turn out being. But more often than not, I found that a thoughtful reference check can yield information and suggestions that you never would have obtained through the vendor due diligence channels. For example, in one situation, we learned from a customer on a reference check that the vendor was in talks to be acquired by a competitor. This was non-public information that had been leaked to the customer by its project manager. Knowing that the vendor was in M&A talks significantly influenced how we approached the transaction and the protections that we put in place. In another situation, we learned through a reference check that the vendor's technology was excellent, but its implementation services group left something to be desired. Where implementation costs can often run 2 to 5 times the cost of the technology itself, this information and the list of the detailed grievances that the customer had was due diligence gold for us in negotiating our implementation statement of work. Now, in order to get this type of information out of a reference check, you need to select the right references. And you can safely assume that any list of references provided by the vendor are safe customers who will undoubtedly sing the praises of the vendor, sometimes because they mean it, other times because they've negotiated price breaks or other incentives for serving as a premier reference for the vendor. And I should probably pause here and say, all this bad talk about the vendor, of course, doesn't apply to Formfast. We're by definition excluding them from my bad vendor scenario, but I'm sure you assumed that already. If you can independently identify customers of the vendor that use their solution, this is ideal. If you can't, then it's often helpful to reject the list of initial references provided by the vendor and demand additional references who meet your specific criteria. For example, who are in similar in size or geography or other features. Also, if you really want to push the vendor's buttons, you should consider asking for a list of former customers who have parted ways with the vendor in favor of another technology within the past few years. And reluctantly, vendors will often provide this list, and yes, you often do get more candid responses from those former clients than you do from existing clients. Once you've identified the field of references, it's helpful to put together a list of the types of questions you want to ask. I actually have a basic starting format that I use to help clients focus not only on the technology, but on the vendor's professional services, management style, vision, and culture. It's helpful to ask very specific questions to the reference, like if you could change any aspect of how you structured or participated in the implementation effort, what would you change? And then drill down from there based on the specific contractual requirements that you have in mind. For a reference check to be meaningful, it's not enough to talk to one person at one level of the reference site. Instead, I recommend setting up the check with multiple personnel at the reference site involved, a senior manager, a project leader, at least one technical expert. Counterparts at your organization should be engaged as well to speak to each of these interests. This can be structured as a group call, although we've often found that you'll get more candid responses if you break into multiple one-on-one calls. At the end of the reference check, all useful knowledge gained and concerns raised and tips offered should be documented, and your team should consider what additional due diligence is necessary and what additional contract protections might be advisable in light of what you've learned. And that really goes back to what I was discussing earlier in terms of having a master issues list where these reference checks aren't conducted in a vacuum, but rather you have a way to filter all the information back to the group. And you'll often find that what was raised in a reference check with one reference will tie into something that someone else discovered doing a news search. And you start putting the pieces together to figure out what your concerns are and what you need to focus on. Another aspect of the relationship that we found is going out of favor as time crunch becomes an issue is the demo, the evaluation, the pilot. The problem we found is that a vendor will always overpromise and underdeliver in its RFP response. The reason is that the RFP stage, the deal's in the hands of the vendor sales team like we discussed, and their job is to do whatever it takes to get you in the door. Short of outright lying, they are more than happy to take creative liberties with your requirements definition. And more often than not, the definitions are plenty vague and susceptible to self-serving interpretations. Therefore, before committing to any significant technology purchase, we recommend putting the vendor's technology through its paces. This can be, in ascending order of preference, a demo, an evaluation, or a pilot. In a demonstration, the vendor runs its solution on the vendor server or machine, either via WebEx or in person, and provides your organization with a general tour of the user experience, or better yet, shows how the software meets each of the criteria identified by you in your RFP. This process is less than ideal, though, for a few reasons. First, the software is installed on the vendor system and not in your unique environment. Second, watching a vendor guide you through its software is not the same as actually using it, and getting feedback from your users on their likes, dislikes, etc. Finally, it's possible for a vendor to augment demo capabilities in a way that doesn't accurately reflect how the product would work in a true production environment. And you think, oh, no, a vendor would never do that. But in fact, we've seen it happen. In fact, we were involved with a radiology group purchasing a new PACS, and the provider courted them with their latest product, and the client had specific requirements at the time for mammography. The vendor did a demo validating these capabilities. On installation, though, the functionality was nowhere to be found. And when we pushed the vendor on this, they confessed that actually the demo was a mock-up of functionality that they hoped to have in their next upgrade, which they couldn't even provide us a time frame for. And so at that point we realized, wow, demos can be dangerous. What you see may not be what you get. Instead of a demo, you should consider requesting an evaluation of the software. In this scenario, you obtain a license to load the software on a temporary basis on your own server and network environment, ideally at no cost. Your IT staff can get a better sense of the fit for your environment and any performance limitations. Your end users can try out the solution and provide feedback on the user experience. And the hands-on experience is likely to prompt additional questions and new requirements that you may not have thought of if you hadn't had a chance to evaluate. We've seen that in many cases the vendor balks at the evaluation and explains that this would require a lot of hardware purchasing, configuration work, or other resource commitments that don't make sense at this stage of the vendor selection process. We see this as both a red herring and a red flag. For any significant technology purchase, you should not underestimate the power of try before you buy. In fact, when you really have something mission critical on the line, we recommend going all the way to a formal pilot. Now, a pilot is much like an evaluation, except that the vendor is paid on a time and materials basis to provide ancillary services in support of the pilot. This might include light installation or configuration of the software, or it might include actual development of a sample interface to one of your more tricky third-party or homegrown systems. More often than not, I've seen these types of pilots pay significant dividends. For instance, if the pilot's successful and you have the peace of mind to proceed with the vendor. Other times, though, the technology is disproven and the vendor gets the boot without having spent significantly more on a full implementation or license purchase to get to this same point. Sometimes you find that the technology works just fine, but over the course of the pilot, you realize it's the wrong relationship and the vendor's removed from the running, again, because you've decided they were a strategic partner misfit before having to proceed with a full negotiation of the contract. So we spent a lot on the vendor selection process and a few shortcomings that I've seen in that process, a few tips that I have on how you can improve that process. I wanted to offer some perspective on the contract negotiation phase too. The contract is often seen as the legal boilerplate, and the way that some of the contracts are drafted by vendors, I can understand why. Some of them are impenetrable, some of them are in multi-parts, some of them have 400 definitions and an appendix at the back giving you the master key to those definitions. They are often not easy documents to read, and in many cases, that's on purpose. And I won't name names, but you can probably think of them and you know who those large players are who have impenetrable legalese strewn throughout their contracts for major investments that you're making. From the client point of view, the goal of that document is very different. The vendor is looking to make sure that they secure you as a customer, set out their reasonable expectations for how they'll support you, and make sure they get paid. Your objectives are really to form a relationship document, not just legal boilerplate. The goal is really to set clear expectations for each party's responsibility during the implementation, launch, and maintenance and support phases, and to provide a means for measuring success in resolving disputes. In that function, I think it is important to have legal counsel that understands how these technology transactions are structured and what they should be looking for in the contract. I know a few of our clients who, prior to our involvement, passed their contracts through legal review, and legal looked at two things. They looked at insurance. They looked at making sure that some boilerplate on HIPAA and other healthcare compliance warranties were there. And those are important things to look for, but it isn't legal review of a contract. It's important that you have an attorney or an outside consultant or in-house counsel that's familiar with these types of contracts, understands the contracting norms, and can help structure the transaction to reflect your legal, business, and technology needs. It's important because you can rest assured that the other side has engaged sophisticated legal counsel to assist them in putting together their contract. And often there's a divide between what your business counterparts at the vendor are willing to commit to and what their own attorneys have put in that document for your review. And again, your job is to have someone on your side who understands that, who can identify those gaps, and who can help you close the delta. Part of that is making sure that all the requirements that we talked about defining up front during the vendor selection process actually find their way into your contract. A major problem, and we'll talk about it in a couple slides, is that often you find that everything you've done up front to find your vendor, to put them through their paces, to make sure they're the right fit for you, all of that disappears at the time you sign the contract. And it's without you knowing it. There's a natural assumption all that hard work pays off, but in most cases when that contract's signed, unless that hard work is poured into the contract, it disappears via an integration clause in the contract. So on the contract itself, as I said, if it's going to be a relationship document, it's important to think about what am I protecting, what do I want to set expectations on at the implementation phase, on the license scope, on the term and termination, on maintenance and support. And I wanted to share with you a few things that we found over the course of many transactions that become key issues which, if handled well by the organization, can significantly mitigate risk. The first is the implementation. And I think, as we all know, the implementation can be one of the most expensive parts of any technology procurement implementation. It can outpace the license costs, the ongoing maintenance and support, and it's because you have a lot of bodies, often on site, working over many months to help deploy a new solution and do all the configuration and customization work, development of interfaces. There's a lot of upfront spend risk in connection with those types of transactions. The traditional way to hedge that risk is to really look at defining the scope of work properly, having a clear change order process. I augment that by making clear that we're going to divide this into milestones and make sure that there are go, no-go decision points at each milestone, so that the client has the opportunity to constantly reevaluate where is the project heading, is it getting off track, how can we get it back on track before we've invested too much or gone over budget without even knowing it. If you do have a well-defined scope, then obviously from the client perspective it's preferable to have a fixed bid or not to exceed pricing rather than paying on a time and materials basis. Sometimes, of course, this is impossible because the scope really isn't a well-defined scope. It's more staff augmentation, where you're paying for the services of folks that don't have defined scope. They just have a shared common objective. The way that we found you can keep the vendor interested in the success of that implementation and make sure that you're not at risk the entire contract price if the implementation doesn't go as planned is to really separate your contractual obligation to pay the vendor for services rendered from your commitment to actually pay their license fees for their software or pay ongoing maintenance and support. And so this is really the pay-as-you-go implementation, where you commit to pay the vendor on a time and materials basis for their services implementing the solution, with an option to license the technology at the end of the implementation if it's validated. This, as you can imagine, particularly with public companies, is anathema from the vendor perspective. It affects their revenue recognition in a way that means they're deferring some of that revenue, the license revenue, until a later quarter or year. At the same time, I think it's critical, particularly when you're looking at large spend implementations. And we have been party to numerous transactions where even after all the vendor selection and due diligence, everyone felt like it was the right pick. And when the parties came together and started putting that technology in play at our client's organization, we all found out it was the wrong pick. And it was a much easier unwind simply owing for the services rendered and not having to sue for a refund of our technology license fees. On the license itself, this is an area I'll cover briefly, but it's worth pointing out that most organizations, you're going to have one contracting party, but the reality is that the users in your organization may be far more than employees of your contracting party. Many hospitals and organizations are set up with affiliates, subsidiaries. Even if you're a single organization, you may have affiliated physician groups that you want to provide with access to your software and solutions, either remotely or actually installed on their systems if they're closely affiliated but not actually a corporate affiliate. You may have strategically aligned third-party providers that you want to have access to the system. Often we see that the vendor proposes to license a specific facility, in which case the contract needs to account for the fact that facilities move. You may be acquired, you may relocate, you may build an additional facility. All these issues need to be addressed when defining the scope of a license grant to software or other technology. Similarly, and particularly when thinking about price, it's important to think about licensing metrics, whether you're getting an enterprise-wide license, whether it's going to be by install or facility, named user or concurrent user, or tied in some way to volume. And we're pricing the metered license, especially by user or install. It's important to think about, well, who should be a paying user for this system, and to really separate out who are our core users and what are our uses or installations that are simply administrative, like having a second installation for disaster recovery or a mirror site, or having administrative and IT staff users who are there to support your core users. If you think about those issues and really separate them out, we found that it's possible to drive down your license price not by changing the actual metric used by your vendor, but by excluding a class of users from that metric. And this is important because if you don't understand how your software or your technology is metered, it can come back to bite in the form of a vendor audit. And we've been involved in numerous audits with some vendors are more aggressive than others, where they want to come on site and check your system and check your records or have phone home reporting capabilities. And you can all of a sudden be hit with 5 years of license charges that you didn't know were on the books and that you weren't budgeting for. Because your users exceeded the scope of licensed authorization. Getting this right up front is important. From a business continuity perspective, we also recommend making sure that if you are surprised by additional licensed users and hit with an additional license fee, the contract makes clear that your true-up for that amount is a sole and exclusive remedy, and the vendor can't threaten to terminate your use of the solution if you're willing to pay. Again, it's not pleasant to have to pay those additional license fees, especially if they're a surprise, but far worse to have mission-critical technology pulled out from under you or be labeled an infringer if you refuse to stop using the technology. On the support and maintenance side, this is an area where we found very often a new client of ours, all their contracts simply have the vendor's standard maintenance and support agreement attached to their contract, and there's been very little thought given to whether that meets their needs, whether it's the right levels of support they need to support their environment, and whether it's the right level of communication that they need from their vendor about their particular environment. One of the things we think with health information technology you really need to look at is whether the vendor is committing to support your solution as configured and implemented for your environment. You know, you've paid $200,000 or millions of dollars to customize and configure this solution to meet your needs, only to find out that the vendor is supporting the out-of-the-box product, and you'll be charged on a time and materials basis for anything that goes wrong with your configured solution. That's a situation that we found clients in and had to help them out of. It's a solution that we try and address up front by making sure that the vendor understands its implementation should account for the fact that at the end of the day, it's going to be responsible for supporting us. And if it wants to design itself into a corner, that's its prerogative, but it can't charge us on a time and materials basis to fix it. So really building quality assurance and regression testing around your configured solution, thinking about even calling out third-party products and interfaces and requiring the vendor to keep pace with those third-party solutions that are critical to your operation. These are all things that typically aren't addressed in the vendor maintenance and support description, but that can be critical to actually getting the value out of those support and maintenance dollars. Similarly, regulatory compliance updates. Vendors are often silent on what they will or won't do to keep pace. Certainly, they have an interest in keeping pace with evolving legal rules that pertain to their solution. But as an organization where it's critical to have those updates, we think it's important to call it out in the maintenance and support description to commit the vendor to deliver those in a timely fashion, to keep pace with evolving law, either through its internal people or through a user group that it has who's on top of that for them, and to even set a threshold, which we found is often a fair compromise, to say, listen, anything that costs less than X to develop, that's part of maintenance and support. If there's a major regulatory overhaul that fundamentally alters yours and everyone else's technology, perhaps that's outside the scope of normal maintenance and support, but the most you can charge us is our pro rata share relative to your other users. These are all things that we found it helps to think about to really set expectations not just for the implementation, but for the ongoing support and viability of a solution. On the subject of ongoing viability, I think it's also important to focus on term and renewal rights, whether each party can elect not to renew at the end of a term, and that could be not renewing the license or not renewing maintenance and support, or whether you say, no, I invested a lot of money in the solution, it's mission critical, my organization should have the right to renew as a matter of right at the end of each term, subject to some predefined price increases. And for mission-critical technology, that's really the better option. You really don't want to be in a place where a vendor can put you at risk of dropping you. And it's something that needs to be negotiated up front. So do all the termination rights where your organization wants to have the right to end the relationship. And that could be for cause, for convenience, upon bankruptcy of either party. If there's an excessive performance failure where you define service levels as part of your definition of the requirements and those aren't being met, having the right to get out based on objective criteria can be far preferable to having to make a for cause or for breach allegation and risk that you didn't actually have the breach case proven. For a change of control, if the vendor sold to another vendor and you don't like the relationship anymore, or if your organization is acquired by someone that has their own technology, those would be reasonable reasons to get out of the relationship. Regulatory compliance, if you can't be in the relationship because they can't keep pace with evolving technology, that would be a good reason to get out of the relationship. But unless it's defined up front in the contract, you may not have that contractual right. Finally, it's important to think about the end of the relationship. It's the contractual prenup, as we like to think about it in the vendor space. With mission-critical technology, it's not enough to say that when the contract ends, you'll pay what's due and your license automatically ends. And that's typically what a software license agreement will say. It's important to think about why the relationship is ending and what you might need in order to keep your operation going until you can transition to an alternative. If the relationship is ending because the vendor is winding down, if they're switching to a new product, you should have the right to switch to that new product with them. If they're going out of business, you should consider a technology escrow so that you have the right to self-support for at least what you can self-support until you find an alternative vendor. If you've chosen to leave the relationship, it may be that finding a new vendor can take 12 months, 18 months, even 24, depending on the size of the implementation. And so we recommend considering whether up front you negotiate a transition and wind down that gives you a right to extend the relationship during that transition period, subject to payment of what would have been the then current fees, we think it's important to also think about requiring the vendor to return all your records, all your data, to cooperate with your new vendor, all with the shared goal of minimizing disruption to your patients. Too often we found that certain vendors, again, none present in this conference, and I won't name the others, go incommunicado when the relationship ends. And that's a problem in any relationship, but it's a real problem where we're dealing with patient records or other mission-critical information, and you need the ability for your doctors and nurses and other people at your organization to access it. There is no time like the beginning of a relationship to set those expectations. It's because of vendors in sales mode that you can ask for those commitments, make them legally binding, and it's a red flag if at the beginning of a relationship the vendor pushes back on what are otherwise reasonable requests. Well, I know we covered a lot of information. My goal today was to give you a virtual smorgasbord of some of the issues we face in trying counsel, and hopefully at least a few of them prompted some thoughts in your mind about relationships with vendors that you've had, things that you wish you'd done differently, or questions that you might have going forward about how to better structure those contracts. And in the time we have remaining, I thought I'd open it up to questions.
Yes, I believe we have one question from Rob here.
Yeah, Zach, Rob Harding here. So, of course, we see a lot of contracts come through Formfast, and say about 40% of them come back uncontested. About 40% have some comments about, HIPAA, picking on certain areas and definitions, and about 20% come back completely rewritten to no evident purpose. But the thing that I find in common is that most of the legal representation for our clients don't really have any knowledge of technology or software-specific issues. So there's a lot of participation in the language around the product, but very little, but not really a participation in what is the product and what are the the specific terms of the purchase. But of course, it's very expensive, to have every piece of paper examined. How would you advise hospitals in selecting counsel? Should they have multiple types of counsel for different types of contracts? Should everybody have an in-house counsel, or what do you think?
Sure. No, it's a good question, and I think you're right on your first point that regardless of which side of the table I'm sitting on, whether I'm representing technology companies or my enterprise clients, there does tend to be a bell curve of responses. And I think what an organization should be looking for is an attorney who understands the issue, who's a repeat player in this particular space. It is a unique space where you have an intersection of intellectual property issues, of commercial contracting issues, of data security and privacy issues, of healthcare regulatory compliance issues that you don't tend to see in other spaces. And if you put this contract in front of someone who's a generalist, you're unlikely to get the type of response that you need. But in terms of when to do it, I think every organization has their own cutoff. My clients included, we tend to get involved on the larger transactions where it merits it. What determines whether it's a larger transaction can depend. It may be based on spend. It may be, though, based on the strategic importance or the risk presented. We've had contracts brought to us, rightfully so, for free data transfer services over the internet that would allow physicians to communicate with patients, to look at the terms of service being offered. And, of course, it was a free service. There was no money at stake, but there were huge compliance issues from a HIPAA perspective that needed to be evaluated. So in fact, with a couple clients, we actually have a intake form where we help them identify some of the key issues that might trigger red flags from the legal department. And they put a request in, and we help them determine who do you need at the table to help out with this. And it is good to figure out what that cutoff is for your organization.
Great. I don't think we have any other questions at this time, Zach, but if we do, we will certainly follow up with you.
Great. Well, it was a pleasure speaking with you all this afternoon.
Great. Thank you so much for your time. We really appreciate it.